we issued a show cause order regarding a citation that you submitted in your brief on page 9, quoting a case Sprague versus Nally. And you did respond to the show cause with an apology letter about the citation, and cited that you got this from a secondary source. And you didn't cite the secondary source. And just, this is no time off for your client's 5-minute argument, but just so that the record is clear, do you have a secondary source that you found the citation in? We were unable to find anything.
Your Honor, my client used an AI helper to draft the original first draft of the brief. So that was a secondary source, Your Honor.
The secondary source was AI,
Right.
and you didn't identify.
I'm not familiar with what's involved with it and so forth. He offered to do an initial draft, and I said that's fine, and that's where that quote came from.
And so it was not a secondary source directly. It was some AI generated source.
Right. That's right.
And do you know what platform was used?
I think he used a couple different platforms, but for whatever reason, it didn't cross-check it. AI GBT or something like that. I didn't use it exactly, but it's a common one, I believe.
But you also didn't check to see its accuracy.
I didn't, Your Honor.
All right,
we tried to go through and check it, but we must have missed it. That's all I can say. It wasn't intentional, and I apologize. It's my fault.
We're going to take that matter up separately from the case, and issue a separate decision regarding the citation and your reference to the secondary source today. Thank you, Justice Eaton.
Thank you, Justice Cohen. The counsel for the appellant, please introduce yourself and your client, and then begin your argument, and your time will start at that point.
Good morning to the court. My name is Donald Lacasio, and I represent the appellant Richard LaRoche in this matter. I'd like to reserve 1 minute for rebuttal, which I've advised the court of. This appeal turns on a couple of narrow issues. First, the family court on remand. Did the family court on remand make the present tense findings that this court requires in making a modification of alimony? And whether Mr. LaRoche's current earning capacity was considered before calculating the arrearage. The lower court did not do that. I'll make 3 brief points, Your Honor. First, the legal standard demands present tense findings under 15 VSA 758, and this court's guidance modification depends on current realities, not on historic titles or theoretical potential earning capacity. The court had to decide whether the compensatory rationale still applies now and whether the payor continues to receive an actual material benefit from the skills developed during the marriage, and then determine current capacity to earn. Second issue, the record shows no ongoing benefit and no present marketability for Mr. LaRoche. The Hexagon Commission job that he had produced no income. That was testified to Mr. LaRoche and not contradicted by testimony. It was confirmed by his 22 and 23 income tax returns. The court identified no other income tied to the marriage enhanced career. On employability, the record shows sustained but unsuccessful job search. And there were no findings or contradictions of that. There are no findings that a comparable position existed for Mr. LaRoche. Without those findings, imputing prior CEO and senior management income to Mr. LaRoche is error. Third, the arrearage it starts on the wrong premise. The court effectively plugged in historic earnings for Mr. LaRoche and then skipped the predicate determinations. That sequence is backwards. The court must first find an actual ongoing compensatory benefit and then determine current capacity and then calculate any amount that might be owed. Absent those present tense findings, the arrearage of over $180,000 lacks adequate foundation and is clear error. And I'll reserve the rest of my time for rebuttal.
All right, thank you, counsel. Counsel for the appellee, please introduce yourself and your client, and then you may proceed with your argument as well.
Thank you, Your Honor. My name is Scott McGee. I represent Darla Sterett. She's the appellee here. This is the second appeal in the same case. The earlier appeal was decided by this court, and the only issue on remand was to calculate arrearages. All of the issues that Mr. Locasio has just identified are not issues that were before the court on remand, and they're not before this court at this point. The only issue after this court determined that was compensatory maintenance and it could not be modified, and that the issue was how much arrearage had accrued. The only issue before the trial court was to determine that accrued arrearage. Judge Treadwell did that, and he did it accurately, and there's no challenge to the amount of the arrearage determined by Judge Treadwell. There really is no basis for this appeal. We asked the court to deny it. I rely on the reply memorandum or reply brief that we filed with the court for the rest of the argument. And unless there's questions, that's all I have.
All right, thank you, counsel. Does counsel for the appellant have any time remaining?
Yes, appellant has 2 minutes and 1 second remaining.
All right, Mr. Locasio, you may proceed.
The appellee's response is that the 2015 stipulation controls, and it does not. The Supreme Court on appeal found that the court made an error with regard to not counting Mr. LaRoche's possible income from Hexagon, which was the job that he had at the time. It was a commission-based level job, and the court simply said it was not related to Mr. LaRoche's prior work history. And the Supreme Court said, no, that's not right for A, B, and C reasons. It does apply and was founded in his prior work history, and therefore that income should be counted. And that's what's been appealed in this case. 15 VSA 758 still exists, and maintenance is modifiable based on the current circumstances of life, and a compensatory award cannot be sustained by a mere relationship to past work. Here, the undisputed evidence shows zero Hexagon income and a faithful and dutiful job search, and the only income that my client has is Social Security. The court statement that the compensatory alimony should be calculated simply left out information for the court to do in addition, which is how much money is he currently making. It didn't just say plug in what he was making as a CEO. It said calculate what the alimony should be based on present circumstances, and it did not do that. This court should remand for finding about what Mr. LaRoche's current earning capacity is and was since the time of the divorce or since the time of the filing in this case, make a determination if there is any compensatory alimony due based on circumstances and facts before the court. Both counsel relied on the prior history of the case and referred to the evidence in the case earlier, and that certainly was part of it. Nothing further.
Thank you very much, counsel. Your time has expired. We will take the matter under advisement, and thank you both for your arguments.
Thank you,
Your
Your
Honor.
Honor.